Hey, Morgan, so I'd like to do PC on this case. This is that stash house.
Yes, we're actually talking to Nathan about that right now.
Nathan,
Yes, sir.
this is a very, it's a first for me,
Okay.
a stash house.
Yeah,
Have you seen this before?
I have, but not for a long time.
And I gotta understand,
I'm looking it up right now.
why is it's not higher up? It's
No,
not
most
like
stash houses
feds?
are misdemeanors. It's strange. Most stash houses are. I teach at the police academy. That's why I know.
Okay, we have to do probable cause, I'm
looking it up. I'm going to try and find the pleading itself right now.
okay. Are you ready?
I'm ready.
Okay, let's do it. What was his name again?
Sure, so it's called, I think it's Adolfo on there, but it's Anulfo
That's right. Mr. Martinez, come on up. Okay. Shh. All right, Mr. Martinez, you were charged with operating a stash house. I wanted to make sure that your lawyer was here when we did probable cause. You have the right to remain silent. Anything you say can or will be used against you. Here we go.
Yes, sir. On November 24th, 2024, the officer was dispatched to an apartment in Harris County, Texas. The officer located 5 adult complainants locked in bedroom while conducting welfare check. The officer observed the defendant to be the sole person in the apartment, not locked in the bedroom. The officer determined the apartment to be under the control of the defendant, and all complainants gave similar statements and stated they were held in the locked bedroom without the ability to come and go freely. The complainants were all found to be in possession of identifying documents, but cell phones had been taken away. The complainant stated if they needed to leave the bedroom, they had to knock on the door and be led through the apartment, sometimes with a bag over their head, by one of 2 males in charge. The defendant stated he lives at the location with another male, but does not know the other male very well.
Okay, whoa. So the defendant says that he lives
At that location,
at the location,
but he does not know the second male that also lives at the location.
doesn't know him well, or
Doesn't
doesn't?
know well.
Okay,
Yes.
all right.
Yes. And the defendant denied knowing the 5 people in the apartment and stated they were dropped off in the morning and that he did not know who dropped them off. The defendant was found with approximately $6,000 on his person, and the officer observed the door where the complainants were to be unable to be locked or unlocked from the inside, only able to be locked from the outside. The room where the complainants were found was free of any furniture, with no mattresses on the floor, and only 3 pillows and multiple blankets. Officers also found a large sheet of plywood covering the window and no working light bulbs. The officer observed a desk in the dining area with 4 envelopes with names in 3,600 written on them containing cash, a total of 11,200. Officers also found a brown wooden baseball bat on the desk with the envelopes.
If I may, Your Honor. So my understanding is that I guess the code says that he has to own the property or rent it, but he was actually renting a room from the guy that lived at that apartment. So he had only paid 1 month of rent to the guy and was going on his 2nd month. He, from my understanding, didn't know who those people were. They had gotten dropped off that morning, and he hadn't left for work yet, was my understanding, that day when the officers showed up. And that's all I know from what I gathered. But he had been living there, and there hadn't been people there until that morning when they arrived, that the officers then arrived at the home.
Did the officers interview him at all?
Interview the defendant?
Uh-huh.
Yes, Your Honor, and that's whenever he told them that he lived at the location, but did not know the person very well, and that he did not know the 5 people inside. And the officer found them locked in the bedroom, but he denied knowing who they were.
So it says here, person commits an offense if the person knowingly, 1, uses or permits another to use any real estate, building, room, tent, vehicle, boat, or other property owned by the person or under the person's control to commit an offense or to facilitate the commission of an offense under.
Which is, Judge, those other sections are smuggling or trafficking.
Right. Or rents or leases any property to another intending that the property be used as subdivision 1.
Which would be him allowing them to use the property for such commission of alleged offense, but it wasn't his. I guess my issue is that it wasn't his property. He was not on the renting or.
And Your Honor, the officers found him to be under the property to be under his control, as they found him to be the only person on the premises at that time, not locked in the bedroom. So yeah, that's why it was the officer's conclusion that he was in control of the property at the time.
What evidence do we, Nathan,
Yes.
what evidence do we have that he knows the persons are being trafficked or being held?
Well, in these cases, typically, Judge, somebody's not gonna come out and say, I know everybody's being trafficked in this room. It's gonna be a matter of circumstances, the totality of the circumstances, I would say, to make that out. And I believe, Judge, based upon the information that we have, that we're at least there for probable cause standards.
And if I may, I did go ahead and read the entire dim summary, and the complaining witnesses that were found in the home did describe 2 individuals, none of which meet the description of my client. They said one of them was a young male with glasses and an older man with a white beard, is what the 2 individuals told the officers.
And Your Honor, in the full DIMS, the complainant one described the.
So hold on a second, because are you telling me that the people who are held captive are saying that it's another 2 people who are acting?
There was, Your Honor, there was a description given, older with gray hair, a round face, and a beard, and the officer observed the description given to fit the physical description of the defendant. So there was a description given by the complainant, and the officer observed it to match the defendant.
Well, but at the time he got arrested, he didn't have a beard, so because the mugshot doesn't show a beard, so I would assume. I mean, I would have to see what they said. I just don't think it's.
I think he's there, he's alone, there's $11,000. I mean.
The other thing too is, Judge, it's my understanding, based upon ADA Farmer's recent, I guess, knowledge of the statute, that it's modified to felonies in some cases, which we may be refining this case as a felony. I always try to warn, I'll just say less experienced defense attorneys when you're doing it, and ultimately probable cause argument, sometimes it comes back worse when you go through the felonies, which I think may happen in that case, that last criminal initiative that's early.
Be careful what you wish for.
So the statute has changed. I haven't seen what the statute says now, but it.
Are you telling me that it changes, does it change January 1st?
It looks like there was an amendment in February. It's still in our system, under our proceedings. It's still looking like a class A misdemeanor, but when you read the Texas Penal Code, under section 20.07, It is a third-degree felony, and that was amended in February.
Oh, yeah. Yeah, look at that. Year 2026. All right, so, Mr. Martinez, I am going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to engage in this behavior, not to be in possession of any weapons. If you pick up a new case, if I find you with a weapon, if you engage in this type of behavior, I will put you in jail. I will not give you any more PR bonds. I don't know what your status in this country is, but if you're in this country without permission and you go to jail and immigration finds you while you are in custody, they will put an immigration detainer on you and you will be stuck in custody until the case is over with and then shipped off to immigration. You are on notice now that I'm going to do everything in my power to protect my county. I don't care who, what, when, where, but if I find that you're a public danger, then I will put you in custody. Do you understand? You have a lawyer. It is your responsibility to stay in touch with counsel, and they will tell you when you have to come back to court. If they tell me that they are unable to reach you because you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest. No more PR bonds for you, sir. So we'll just have him sign the bond conditions and then he's free to go with you.
Thank you, Judge.
Yes, ma'am. And so for what it's worth, it is now a third-degree felony. So I don't know how it's still a Class A at this moment. So
Correct. Let me,
that is charged as an A versus a third degree.
correct. Let me look into
So,
that.
yeah, okay. All right, sir. Do not leave, Roberto. If you can tell him, don't leave until he signs bond conditions, please. And then if you can follow those, please.
And just to clarify, no engaging in like behavior and
No weapons, right? Yeah. And no going back to this particular house.
Yes.
Connor, you ready? Come on. Okay, do you have a plea?
Yes.
I'm ready when you are.
This is what's wild. He's getting a deal most defendants could only dream about. Avoiding a felony changes your entire future. Would you take that offer or fight the case?
All right, Mr. Sprague, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 12-month deferred. This is the type of probation that if you successfully complete it, you do not end up with a conviction on your record. And I'm going to tell you that this is extremely important for you because this is the type of offense where a second conviction requires a 10-year registration requirement under Chapter 62, which is, you know what I'm talking about?
Yes.
And I'm
Yes,
telling
Judge.
you, when you have to register under this chapter, it is a very, very difficult thing to maintain.
Yes, Judge.
As part of the agreement, you must do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. You will do no drugs, no alcohol, 10 hours of community service, $100 donation to the Houston Area Women's Center, and no threatening, threatening, or abusive contact with
Samaya and Saj.
If you violate this agreement, I will issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out and we are going to talk about whether you violated this agreement. If you did, you're looking at 180 days in jail. Do you understand?
Yes, Judge.
So you're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you enter into this agreement, you are stuck with us until you complete it or unless you get revoked. The way that you behaved while you were on bond for this case is unacceptable. And if you think that you're going to do the same thing while you're on probation, just got to be careful. Do you understand?
Really quick, on bond, he was compliant. It was, the only reason he missed court was because of my mistake.
But you need to know. I mean, it is your responsibility to also know, right? We rarely close, we're always open like Costco, man,
All right, yes, Judge.
That's why I'm not putting you into custody now. Otherwise, right, you would be staying with us. What do you do with yourself these days?
Contract work, but since my boss is retiring, I'm actually looking for a steady income instead. So applying for everything.
So are you actually working now as what?
Yeah, just been helping with the fences, most all those fences going down, just building fences.
It's a great occupation. I'll tell you what, fencing, you can make a ton of money if you do a good job. You put your heart, soul into it. You do well. Your name will spread like wildfire. And I'm telling you, building fences, it's crazy expensive. I mean, who knew? Right. So if you do well, you can make a lot of money, So what kind of income do you have now?
At the moment, not too much because my boss is retiring, which is why I was looking for actual steady income, honestly, because my boss was the one that was helping me out a bunch, but he's hitting 75 and he's kind of done with it, so.
Okay. So you can reduce it to the minimum. Okay. So how do you plead to this offense? Guilty or not guilty?
Guilty.
I will not find you guilty. I'll withhold that for 12 months. If you do well, if you get everything done quick, I'll take you off in half the time as a reward. We want you to do well. And if you do well, get everything done and you're nice to everybody, I'll take you off in half the time. All right? Okay, man. Good luck to you.
Thank you, Judge.
Thank you, Connors. Hey, good morning.
Excuse me, you step forward.
Did you say Herrera?
Yes, Judge.
Okay. You're Moises Herrera.
Yes, sir.
Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On November 24th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it stopped at a red light in the opposite lane of travel. Upon contact with the defendant, the officer observed him to have red, watery eyes, slow, slurred speech, and a strong odor of an alcoholic beverage. The officer also observed an open bottle of tequila in the driver's seat back pocket, and the defendant admitted to drinking. Standard field sobriety tests were performed, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The DIC was red and the defendant consented to breath. The results were 0.141 and 0.130.
Okay. Are you trying to tell me that he's consuming alcohol while he's driving?
There's no indications that it was in the pocket behind the driver's seat.
I see. All right. Mr. Herrera, I'm going to find that there's probable cause to go forward with the case. Tell me, how old are you, sir? What do you do for a living? I see that you have a lawyer, correct?
Right.
Okay. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, I do.
He's eligible, Your Honor.
You have liability insurance in your name.
Of course.
You have car insurance. All right. Good. Good job. So I'm going to have you sign a receipt. Victoria will have you meet with Fleischer of your bond conditions, and then we'll just have you take a seat and wait for your lawyer to arrive. Okay? Please.
Johnson, page 19. Moesha.
Good morning, Ms. Johnson. Ma'am, you were charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir. The officer was dispatched to a disturbance in Harris County, Texas. The complainant and the first witness, the complainant's mother, stated that the defendant had been texting and posting on Instagram about wanting to fight the complainant. The complainant and defendant were inside an apartment when the fight began. The witness stated that she observed the defendant to have a small sharp blade in between her knuckles when hitting the complainant. The defendant punched the complainant in the face, causing lacerations and pain. The defendant told the officers that the complainant believed that defendant was with the complainant's ex-boyfriend, which is what started the fight.
And it's just an assault?
Yes, Judge.
Johnson, I'm going to find that there's probable cause to go forward with the case. I'm shocked that it's not an aggravated assault. Let me tell you, I'm ordering you now as a condition of your bond not to be in possession of any weapons and not to have contact with the complaining witness in this case. Do you understand? Yes or no?
Yes.
I want you to understand that I'm going to do everything in my power to protect the public and every single person in it. And if that means locking you up and putting the bond extremely high, I will do it in a heartbeat. Do you understand?
Yes.
We are going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box. While we get your bond conditions, we'll have you sign it, and then you'll be on your way. Do not have contact with this complaining witness. Do you understand, ma'am? No more warnings. You will get no more warnings from us.
Next judge is page 20. Jones, DeMarcus.
Good morning, Mr. Jones. Sir, you are charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, officer conducted a traffic stop on the defendant's vehicle after observing it to fail to signal when changing lanes. Upon contact with the vehicle, the officer observed a strong odor of marijuana. The defendant was the driver of the vehicle, and there were 3 other occupants. A PC search of the vehicle revealed 2 bags containing 31.33 grams of marijuana within the reach of defendant's wingspan. The 3 other occupants of the vehicle denied ownership of the marijuana.
He's in the box. Yeah, if you want to take him out, I haven't done probable cause, so we need him. Just don't. Yeah, you can take him out, but just bring him back. Okay, Mr. Jones, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license, sir? You are not allowed to drive. I don't care what your reason is. I don't care where you're going. I don't care what you have to do. Mother Teresa needs to ride to church. I don't care. Do not drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand? You can be facing an additional 6 months in jail and a $500 fine every time you drive. Don't do it. Here's the other kicker. You're on bond for a felony theft case. It's very possible with this new case that you picked up, they revoked the bond and issue a felony warrant. So.
Take your hood off.
All right, Mr. Jones, I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria. We're going to have you sign a reset. After that, you'll get out of here. When you come back, please have a lawyer, sir.
All right, judge, page 20 and 21. Jones, Jared. Raise your right hand.
The lady in the middle?
Jared Jones. Mr. Jones, you're charged with assault, bodily injury. You're also charged with criminal mischief. On the assault, you're facing a year in jail and or a $4,000 fine. And on the criminal mischief, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 23rd, 2024, officers were dispatched to an assault injury report call at a residence in Harris County, Texas. Upon arrival, the officers met with the complainant, who stated the defendant was watching her kids. When the complainant went to pick up her kids and went to the witness's house, the defendant became angry. The complainant did not take him. The complainant stated that when the defendant had arrived at the witness's residence, he was taking off his clothes in the driveway, trying to fight her. The defendant then approached her motor vehicle and struck it with his right arm, breaking her passenger front window, costing approximately $200 to repair. After the complainant pushed the defendant away from her vehicle, the defendant began striking her in the face with a closed fist 5 times. The complainant stated she felt pain, and the officer observed the complainant's rear or front passenger window to be shattered and observed the defendant's right forearm to have a minor incision from the glass of the window.
Mr. Jones, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with this person. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of any weapons.
Yes, sir.
What is the relationship between these two? Do you know, Alex?
Let me see.
So, Mr. Jones, we are going to reset your case to give you time to hire a lawyer. I will first have you go to Victoria, sign a reset. I'm then going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be on your way. You already have 2 cases now. Don't pick up a third. If I find that you're a danger to my public, I'm going to put you in jail. You will not get more PR bonds. Do you understand, sir?
Your Honor, they're just friends.
All right, come on. Can you file no contact and no weapons charge?
Imagine losing your freedom over something a $12 Uber could have prevented. The judge isn't just angry. He's exhausted from seeing the same story on repeat. Do you think tough talk actually changes behavior? Or does it just make defendants tune out?
Lockridge, page 24.
Okay. All right. Good morning, Mr. Lockridge.
Hey.
So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 20th, 2024, the officer was dispatched to a group home in Harris County, Texas. Upon arrival, the officer spoke with the complainant, who advised that after her and the defendant, another resident of the home, got into a verbal argument, the defendant told him, "I'm going to fuck you up." The complainant stated the defendant then went outside, grabbed a bed frame, and stated he would tear this place up. The complainant advised he was not in fear, but advised he would like to pursue charges because he perceived the statement as a threat.
He's not in fear.
Yes.
You know? All right. I'm going to find no probable cause on your case, Mr. Lockridge, but be careful.
Yes.
You know, when you get upset and you say things that you really don't mean, they can get you in a lot of trouble, right? Have patience. It's not hard. And if you get upset, walk away, find another release. But sticks and stones may bring you back to us, and you don't want to come back here. All right? Okay, man, just take a seat for me, okay?
We'll
Please.
dismiss it, Judge.
Please.
Next judge is Escobar Tobar, page 13.
So I was, come on up. I was going to do a deeper dive on it to see whether there's probable cause. It's first time I've seen something like this.
Yeah, same here, Judge.
Do you mind do you have somewhere else to go?
I do.
Can you go do that and just come back maybe
Yes,
in
sir.
like an hour? Let me blow through all the arraignments and then
No
we'll
problem.
sit.
I'm gonna just let my client know and I'll be right back.
Yeah, I mean, I want to open the code. Let's go through it and take time, you know? Yeah, okay, sure.
All right, Judge?
Um,
Counsel, do you have an arraignment? Okay. Page
I know who
25.
you're here on,
McAlpin?
but I'd like to do the arraignments real quick, then I'll help you out.
Straight House, 25, McAlpin, Straight House?
Mr. McAlpin, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, the officer was dispatched to a residence in Harris County, Texas, in reference to an indecent exposure call. And upon arrival, the officer met with the complainant, who stated that he observed the defendant inside his property without pants and underwear on. The complainant stated that he observed the defendant dry hump the air and roll around on the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be open and observed his credit card missing and his in-car charger to be damaged. The defendant was the only person inside the property at the time of discovery.
Trespass of what?
See how it's pled, Your Honor.
Is it house? Is it car? Did I miss something?
Your Honor, it just pled as being on the property. It doesn't specify if it was a vehicle, so. The complaint just stated that the defendant was inside his property area.
Was there prior notice of him not to be there? Or, because I didn't hear you say anything about prior notice. I didn't hear anything about you saying,
Your Honor, it was just a residence, and in the case of a residence, notice is presumed, and he was.
no, we don't presume anything in the law, you know? I mean, we don't go based on hunches and, read it to me again, please.
Yes, Your Honor. On November 24th, 2024, officer was dispatched to a residence in Harris County, Texas, in response to indecent exposure. The complainant stated he observed the defendant inside of his property without pants and underwear on. The complainant stated he observed the defendant dry hump the air and roll around in the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be opened and observed the credit card missing and in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Yeah, I mean, there's no prior notice that he's not supposed to be there. You didn't say anything. You didn't say anything about he's
There's
trying
no
to,
statement as to without permission. The only thing is it is a residential area, Your Honor.
all right, I'm not going to find probable cause to go forward, Mr. McAlpin, but you're on notice now. If you go back to this place, they're going to probably arrest you. Do not go back to this place. Watch out what you're doing. You're on felony deferred for a very serious crime that can give you 10 years in prison. Do you understand?
Yes, sir.
Behave yourself in the free world. And if you cannot, you're going to end up possibly 10 years. You understand?
Yes, sir, Your Honor.
Take a seat.
Thank you.
Ella Bedoy, page 26.
Hold on a second. Just, I'm waiting for Mark. So just take a seat for me and we'll be back with you here shortly, okay?
All right, Judge.
Hey, wait, Vic.
30 Perez.
Okay,
Thank you, Judge.
you've done it already?
Yes, I appreciate that.
Quick.
Thank you very much.
Sure, of course. You are Marcos Perez. Mr. Perez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Is his last name spelled correctly with an S at the end, or should
Yes,
it be with a
Judge.
Z? S is correct?
Yes.
Please, Alex.
One moment, all right, let me pull up the correct arrest. Okay. On November 23rd, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane of traffic and almost strike other motorists. Upon contact with the defendant, the officer observed a moderate odor of alcoholic beverage. The defendant admitted to drinking 2 alcoholic beverages. Centerfield sobriety tests were performed, HGN 4 out of 6, walk and turn 3 out of 8, 1 leg stand 2 out of 4. The DIC was read and the defendant consented to arrest. The results were .094 and .089.
Any prior to DPIs?
No, Your Honor.
Mr. Perez, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen? Are you in this country with or without permission?
No.
You're not in this country with permission.
No.
What happens if you go to jail? Don't tell him, Marcos.
Familia, esposa y 2 hijos.
I have a family, wife, and 2 daughters.
I don't care if Jesus lives with you, Mr. Perez. If you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put an immigration detainer on you and you will be stuck in custody until this case is over with and then shipped off to immigration. If you do not want that to happen, do not violate these conditions. I'm putting conditions on your bond now. If you violate these conditions, I will put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. It takes a while to resolve this case and then shipped off to immigration where you'll sit for another 6 to 9 months. I'm ordering you now as a condition of your bond not to drive. If you do not have a Texas driver license and you do not have liability insurance, do not drive. Do you understand? I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You have a lawyer. Good job on having a lawyer. It is your responsibility to stay in touch with Mr. Adroge. He will tell you when you have to come back to court. If he tells me he cannot get a hold of you, likewise, we will issue a warrant for your arrest. Do you have any questions, Mr. Perez?
Sir,
I'm not asking much from you. I'm just asking you to follow the law. And if you can't, or if you come a danger to my community, I will do everything in my power to protect it. I will have you come up here, swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a reset. After that, you'll get with Felicia for your bond conditions. And after that, you guys are free to go.
Thank you, Judge. Appreciate it.
Good luck, guys.
Pat, Joshua, page 30.
Joshua Pack.
Sir.
Good morning, sir. So you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. There's a co-defendant in this case.
Yes, Judge. And
Stop. Just don't say anything. I know tensions run high. Just,
Okay, pause for a second. Did you catch that? This defendant's being accused of harassing a dog, not the owner of the dog. Legally, that's wild. Normally, harassment applies to humans, not pets, unless it's tied to cruelty or threats against the owner. So right now, the judge is trying to figure out if barking can be the basis of a criminal charge. You can almost feel the courtroom trying not to laugh.
the co-defendant, it has an evading in court 13.
do you have the cause number on that one?
Yes, Judge. One
What is
moment. Cause number 253-9856.
Okay, so it looks like we've got the lower cause number. Did you get it? No, that's not right. Let me see.
It should be a JV on dates.
Okay, no, I didn't.
Yeah, it's 253-9856. So it looks like we got it. Okay. So, Mr. Pack, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes,
Okay, please.
On November 21st, 2024, the officer observed the co-defendant loitering at a gas station, not conducting his business while on proactive patrol of the area, known to have frequent narcotics trafficking and gang activity in Harris County, Texas. The officer observed the co-defendant grabbing the waistband of his pants and clutching what appeared to be a pistol, and the officer approached the co-defendant and the occupant of the motor vehicle he was speaking to, informed the co-defendant he was going to be pat down. The co-defendant then evaded on foot for approximately 0.25 miles, where he was eventually detained. The defendant then ran up to the scene and was yelling at the officer, acting irate. The officer repeatedly had to instruct the defendant to give space for the investigation, and the defendant followed the officer on foot as the officer walked the co-defendant back to the gas station. The officer observed on surveillance the defendant to be carrying what appeared to be a handgun in his waistband and clutching it before passing it to another male. The officer went to pat down the defendant to ensure he was not still armed, and the defendant pulled his body away, stepped away, flailed his arms, and tensed his body. The officer was struck on the jaw by the defendant's flailing arms, and the officer performed a double leg takedown and instructed the defendant to stop resisting and give his arms. The defendant continued to tense his body and pull his arms away.
What was he under arrest for?
So they were attempting to perform a search at the time, a pat down for weapons because they observed him to have a firearm on surveillance.
Okay. All right, Mr. Pack, I'm going to find that there's probable cause to go forward with the case. I'm going to do it with my pen. I'm not going to put any conditions on your bond. Just be careful out there. You know, really, you're on bond for another case now. It's very possible that they use this against you. Got to be careful out there.
Yes, sir.
The only condition I want you to have is just don't have contact with the co-defendant in this case.
Sir.
Okay, that's it. What do you do for a living?
I'm a referral. I just quit my job from driving truck.
Why? Why'd you quit?
I just had a son. I spent my son was born on my birthday, November 22nd. I spent it in here.
How you making money?
I started my own holiday service.
Do you have an income now? Do you have an income now?
I have enough to sustain me, but I will need a lawyer.
Can you afford one? Let's do this. I'll have you fill out an application. I want to take a look at your financials. Be honest. Don't just put zeros because I'm going to send it back to you. And then I'll take a look. Okay? All right, man. Do you mind giving me an application? Just give me a second.